We appreciate any questions you have. Feel free to put them in, and we will certainly try to answer them for you today. My name is Shelly Mark, and I'm here with Kerry Baker, and we're just going to kind of get started with some of these questions and see if we can get you guys some help. Okay. All right. I'll read these. I was denied for Meniere's disease, service connected for tinnitus. I did submit a Nexus letter. What would be the next step? This says HLR, which stands for higher level review. Um, what do you think, Kerry?
I think it depends. I mean, typically, VA likely, and I'm kind of reading between the lines here, VA likely got a medical opinion that said it's not related, and they probably took more, gave that more probative value, or they didn't get an opinion and they just don't typically see a link between tinnitus and Meniere's disease. If they did that, that's what we call a Colvin violation because they're not supposed to make that medical determination. Um, but as far as what to do, you're right. It looks like you're asking if HLR is next step. I would say yes. If you've got a good medical opinion, if you're doing this on your own, you can do an HLR and ask for a conference. Give them your phone number; they'll call you, or you don't have to have a conference. I mean, that's up to you. Or you can go to the Board of Veterans Appeals. If you did that, I would do the direct lane, not the evidence and not the hearing lane. If you've already got a nexus and it was considered, uh, if that nexus is new and it's not been put in the record, then you're going to have to do a supplemental claim with the new evidence. So that's what I would say on that.
Yeah. Yeah, I agree. I agree with Carrie on that. I would do higher level review if you wanted to file an appeal because you don't need to submit new evidence, so you don't need a supplemental. If you submit a claim years ago and it was denied, and then submit a supplemental claim for the same issue and get approved, do you receive back pay from the date of the old claim or the new claim? Um, so normally, if you submit to reopen a claim, you would have to have some new evidence to do so. And the effective date for that new claim is going to be the date that you filed to reopen the claim. There are certain situations to where you could potentially argue back to that earlier effective date. There's a number of different reasons why. Um, we could attempt to get back to the earlier effective date, but normally the effective date that's going to very likely be assigned is going to be the day you file the new claim. But that's definitely something that you would probably want to get an attorney or someone to look at, just to go through the evidence that's in the file to see if there's any way to argue for the earlier effective date. If you have an appeal at the BVA, but you have additional new disabilities to claim, will the VA allow this, and is it advisable?
Let me try to
Carrie,
jump
you
in
want
here. Yeah, we get asked that a lot. Now that can how that's being asked, that can mean a lot of things. Are you asking if you can file new issues with the BVA, the Board of Veterans Appeals? The answer there is no. If the RO has not decided those issues, you cannot add them to the appeal at the board. There's no questions on that. But can you file a new claim for something else while you have an appeal at the board? Absolutely. All right. If you've got a mental health claim or whatever kind of claim on appeal at the board, and you realize there's something else you might be entitled to completely different than what's on appeal at the board, uh, you can file a claim just like you would file in the original claim. Here's the thing: a lot of people out there are going to tell you, oh, wait till that appeal's done. Especially some of your VSO reps out there. I disagree. If you've got a valid claim for something,
yeah.
get it in the record now and get it filed. You have to start from scratch with it. If it's a brand new claim, like I said, you can't add it to the one at the board. Um, but and keep in mind, if you're going to do that, think hard about other claims that you think you might have and put them in there too. All right. It's overly complicated these days when you piecemeal claims in. In other words, you file one claim 1 month, another one the next month, another one 6 months later, which you can do. But man, that makes that claim complicated just to track because of the way VA handles those now. Get them all at once and then move forward with it.
I received 70% for my PTSD 2 years ago, and now I'm getting therapy and treatment for insomnia with VA doctor. Can I submit a claim for insomnia as secondary to my PTSD, or is insomnia part of my PTSD symptoms? That's a good question and one that we get a lot. And the answer is that that is going to be considered a symptom of the PTSD. And so you're not going to be able to file a claim for that and get an additional mental health rating in addition to the 70% for the PTSD. I would say if you're in treatment and therapy and you're having your symptoms are worsening to some degree, that you may consider filing for an increased rating rather than filing for the symptom of insomnia.
Yeah, I agree. Yeah, one way to determine that, if you're studious and know how to look up the regulations, is go to the VA's rating criteria for that disability. If it includes that symptom, which the mental health rating criteria does include sleep disturbances for mental health disabilities, then odds are you're not going to be able to get a separate rating for that because it's considered pyramiding, which VA won't do. So.
Should I enroll in vocational rehabilitation if I have an appeal out, including TDIU, which is the individual unemployability? Will enrollment in vocational rehabilitation lessen my chance of having the IU awarded? Um, I'll let you answer, Kerry.
I'd say it depends. I mean, if you go strictly off of VA regulations, then the answer should be no. It should not lessen your chance. But you're dealing with people that sometimes have a hard time keeping their uh, subjective opinions out of their what should be objective decisions. Um, and it's going to be dependent on the facts of each case. The fact that you've been granted eligibility for VR&E shows you have an employment handicap or even a serious employment handicap. Uh, but it doesn't mean you're employed or employable. So if you file for TDIU, if you have TDIU already awarded, especially if you have it awarded, so let's go down that road. If you're already getting TDIU, one, do you want to go back to work? Okay. If the answer is yes, and you think you can overcome your disability, and you will do it through VR&E, they are not supposed to reduce your unemployability until you've gone through the program and been employed for a year to show that you can maintain that employment. That should, in all respects, be the same rules that they follow if you have a TDIU claim pending and are enrolled in VR&E. All right. But at the same time, you're going to see some decision makers look at that and go, oh, well, you can go to school, you can work. That may or may not be the situation. Maybe you're going to school online. Another thing to consider is if you are on unemployability and you don't think you can work, but you'd like to learn something new or go to VR&E, there's another program called, and I'm going to mess this up a little bit, but it's a program of independent living that they can qualify you for, and that is simply, think of it like a hobby. Okay, you're unemployable, but you want to be independent in some way. I've seen people who have gotten it. I really liked it. They can take computer classes. They can become a botanist. I mean, it's not something that you're going to be employed by. Some do woodworking, you know, and if you're going to stay on unemployability, that's an option. It's a limited availability to get into that program. It's been a number of years since I've been directly involved with it, but it is a good program for those that qualify. So all in all, it depends. There's no solid yes or no for that. If they follow the law, the fact that you're there alone in VR&E should not disqualify you for TDIU. But if you succeed with it and become employed, it will eventually. So just keep that in mind.
I was service connected for deviated septum at 10% and then had a surgery to fix it. How do I go about removing the service connected condition, deviated septum?
Why would you?
That's true. And if anything, yeah, would it just
Yeah,
something that they would do independently, right?
yeah, because you have surgery, you know, you're not under an obligation to go, hey, I don't have this disability anymore. Please take it away from me. If you want to do that out of a moral sense of responsibility, I mean, you're allowed to, but keep in mind that's called a recession of benefits. I don't have the stuff in front of me to read, but it's basically where you say, hey, I don't want these benefits anymore. You can take them back. And excuse me for not giving the exact nomenclature, but that is an all or nothing thing. So keep that in mind. So if you're getting benefits for, say, a back problem, knee problems, and you think the deviated septum is fixed, you can't turn in, so to speak, that 10% or that service connection without getting rid of the rest of them. Okay. If it's improved, they can always reduce that particular disability down to 0%. And that's up to you whether you want to, but simply because you've had the surgery and it's better, you know, there's no legal obligation for you to say, hey, take away my service connection. So just keep that in mind. If you need to do it for other reasons, then, you know, how you do it would simply be writing into VA, telling them, look, this is improved. You can have your 10%, but don't tell them you can have your, you can have your disability back, because you could be giving up a whole lot more than you didn't even realize. And while it's service connected, even at 0%, something goes wrong down the road, and it flares back up again, even though it may not be deviated, you're still service connected and still get health care for that issue. So, you know, keep that in mind.
When will the AMA supplemental claims be processed? The AMA supplemental claims should be processing as we speak. We have filed a number of supplemental claims over the past 2 years, I would say, if not more. And we've definitely been receiving decisions back from the regional offices on our supplemental claims. Um, I don't want to try to give a time frame because it varies so much. Um, but you should definitely be getting decisions on the supplemental claims that you're filing.
Yeah. And if you put one in a year ago, 2 years ago, and you don't have a decision yet, then you might want to check with VA to make sure something didn't happen to that claim. We're talking VA here. You know, they can screw up with most things. But you're right, some of them
Yeah,
are done.
that's a good point.
Right. Yeah, some are done within 60
Especially,
days. And I'm sorry, go ahead, Shelly.
no. I'm sorry, Kerry. Go ahead.
I'll say some are done like within 60 days, and some have complicated like exposure research things they have to look up, like blue water or whatever. And that might take them a year and a half or so to get some of that research done. So it varies widely uh, yeah, on the claim, but you want to make sure it's still pending. And you can probably do that by, you know, calling the toll-free number, or if you have a rep, checking with them. And they can tell you that. At least they should be able to tell you that.
And Kerry, I was just going to add that between all the notices that we received telling us and veterans that they've submitted the incorrect forms and you
Mhm.
should have submitted a higher level review and not a supplemental claim, and they're not correct, but they do stop processing the claim. So I think that's a really good point to just check and make sure that it is still actually pending.
Yeah, and on that note, I've seen them. So if you don't say you didn't submit new and relevant evidence, or at least they think you didn't submit new and relevant evidence for the claim, they owe you a decision saying it's denied because you didn't submit new and relevant evidence. But I have seen VA cancel those claims. I don't know where they're getting some of this stuff, who's training them, but it's incorrect. All right. They cannot just cancel a claim because you didn't submit new and relevant evidence, but I have seen them do that. So just, something to keep in mind.
How should you structure a higher level review document to make it effective with the VA?
Well, they got a
Well,
higher level review form. Yeah.
got to use the form. Uh, you have to use the form for the higher level review. I will say that if you want to add a state, well, as long as it's you can add a
An
statement
argument.
with that as long as it's not something new. You can add an argument, correct? But other than that, that's really the only way that you would format it. Like Carrie said earlier, though, you can request a conference on a higher level review, and that may be a little bit more effective way for you to present your argument or your position.
And the question is, how do you structure your argument? Well, there are plenty of ways to do that. There's no one way. If you're talking about sitting down at your computer and writing out an argument, which you can do with an HLR, that's not considered new evidence. Um, which you can't submit new evidence with an HLR, but an argument's not new evidence. Um, if you're doing it yourself, there's no specific format you need to use. Just communicate clearly. I mean, hell, we have different formats that we use internally in our office from one person to the next sometimes. VA doesn't care. They get them all kinds of formats.
There is a job posting for remote virtual staff attorneys at the board, the BVA. There are multiple open positions. What are your thoughts on this? Um, my understanding is that the board had just filled a number of attorney positions, um, but I don't know if there's still any outstanding or open positions. So that's as far as I know on that issue.
Yeah, and it also it depends on what the basis of the question is. Are you an attorney and want to go work for the board? You if I had a law degree, I would probably not. Just my opinion. There are good benefits in the federal government. Uh, if you're wondering if the are they short staffed? Like Shelly said, they've hired a lot of people. But because they're so big, they're always going to have openings, either through attrition or whatever. So I wouldn't take that. I wouldn't try to read between the lines and say, oh, the board can't keep employees or the board needs employees. I mean, yeah, they always need employees or better ones. They probably get pissed at me for saying that, but if you're an attorney and want to go work for them, you know, that's a judgment call you have to make yourself.
Back in 2008, during my C&P, I complained of pain shooting down my legs. It was noted in the decision letter, but not addressed. I recently received 20% for each leg sciatica. Was this a pending unadjudicated claim, and is the 2008 effective date possible? I'm a little confused, but I think that so the original claim was 2008, and it I believe what they're saying is that at the C&P it was raised maybe by the examiner, but the rating decision after the CMP did not address that as a secondary condition. And then more recently, they've been rated 20% for each leg, and they're wanting to know if they can get the earlier effective date to 2008 based on it being an unadjudicated claim. That's my understanding of what the question was.
I'm not
Uh,
100% certain myself on what, because it said it
that
was.
depends, right?
That's going to depend. But let's just say the question's premised on, they granted service connection for your back condition, and you had radiculopathy down each leg, and it was on the exam but not on the rating. I almost took it the other way, like the rating decision addressed it, but the exam did not, which would be odd. But I think they probably meant the opposite, so that it was addressed on the rating and not on the exam. Um, First, did they service connect the underlying condition causing it? If they did not until more recently, then no, because you're not going to get an earlier effective date for a secondary condition when they denied the underlying condition. If they granted the underlying condition and just failed to even address the radiculopathy, question is, were they required to? All right, and that may be a yes on something like that. You could argue that it's an unadjudicated claim. You could argue that it's a CUE, a clear and unmistakable error, if the examiner clearly attributed the radiculopathy to the service-connected condition and there was nothing to the contrary. Did they have a duty to address that? I would say yeah, because that would be then, according to the record, a known residual of the underlying condition that they failed to address. But that's if all the cards kind of stack up correctly there. There could be lots of reasons that they didn't. Maybe the examiner did not state whether it was due to the back condition, if that's what we're talking about. Maybe they said it wasn't, and they just didn't address that in the rating, and you didn't otherwise know. Maybe they said there's no objective evidence of radiculopathy, even though you said your legs hurt. I've seen that happen a lot of times, and so it will look like to the rater that there's no diagnosis, even though you complained of it. It's a crappy exam where they say there's no objective evidence of radiculopathy, even though there's subjective evidence. Well, what is objective evidence of radiculopathy? Usually on a CMP exam, it's you complaining of your legs hurting. That as far as it goes. So it's a big if. Okay, can you try it? Sure, you have nothing to lose. But if you're going to do it, I would phrase it as a CUE or the alternative, an unadjudicated claim, or vice versa. But I would put both of them on there if you're going to try something like that. So I hope that makes sense.
If I decline to see a psych doctor because I work there at the time, is that denying depression? I complained to my general practitioner doctor about depression for 4 years, even conducted suicide screens. Um,
Is that denying depression? No. Well, yeah,
it's
I think
they may think that's saying maybe is that a basis for denying?
it's unclear if you're asking, is that you denying that you have depression, or is that a basis for VA denying the depression? I guess it depends on how you're asking that question. Or
Yeah.
um, is it VA trying to set you up with an examination with that doctor and you refuse because you work there? And that would be a third scenario. Okay. And now the third scenario, and I don't know if that's what you're asking or not, they are not supposed to examine you where you work. If you work for VHA, that's a conflict of interest. They're supposed to examine you somewhere else. Just like if you're a VA employee and you've got your own claim, it's not supposed to be rated in the office that you work at. So apart from that, I would say it depends on it depends on how you're asking a question. I wouldn't say no. It's not that you're denying depression, and it shouldn't be a basis
Yeah.
for a denial, really. What do you think, Shelley?
I agree with you. And after rereading the question, I believe it may have been asked in the context that you were saying as an employee and having the conflict of interest. But I agree with you. I don't think it means that you're denying depression, or I don't think it's a basis for them denying the depression claim either.
Yeah. Yeah, and if it is an issue with a CMP exam and you're trying to get the claim through and you refuse that, I would be careful and just send VA a letter or something, letting them know, hey, I work here. That's why I'm choosing not to be seen by this doctor. If VA is trying to set you up with something like that, if you complain to it with your GP, well, then it's on record. So you've got that going for you already. So yeah, I think you have a valid position there either way, I think.
I'm filing a claim for the first time. I have hypertension and ischemic heart disease. Do I apply for both on different lines, or just apply for one at a time? I believe this is asking a question as far as how to apply for it on the form.
That's what I think.
If you're filing for yeah, if you're filing for the first time, you would use the VA form 526. You can list the conditions down on separate forms. There's plenty of lines there for you to list out your conditions. Um, I would wonder here if this is a Vietnam vet and whether or not these are presumptive conditions. Just curiosity there, but either way, you would use a 526 form and you can submit or you can list the conditions. Several, as Kerry said earlier, you can go ahead and list as many as you feel are service connected, and then get it submitted that way.
Yeah, yeah. Do it on one form. That's how I'm taking that question to you, and do it as on different lines because those are two separate disabilities technically, uh, and you should be fine with that. Yeah.
Okay. Says 60% to 100% due to an increase in disability. Um, that's 7 March intent. I'm assuming that means that that's when the intent to file was submitted. 7 December effective. How do I calculate back pay? Um,
Yeah, that's a little.
that's confusing.
Yeah,
Sorry, I'm not sure.
yeah. If let's say we're talking 2022 because we don't know, it doesn't say in the question. If you submitted a intent to file in March 2022 and you got a decision and they made the effective date in December of 2022, well, then I would appeal for an earlier effective date. And yeah, your back pay is going to be low because it's only going to go to December 2022. But I don't know if that's what you're asking or not, or if you know if it's vice versa. You want March of 2021. It, I, yeah, we're just not sure. But remember, when you calculate
Yeah.
your back pay, the month that it starts in. Let's just say it went to March, and I don't think that's what you're saying, but maybe you got the decision in December and it was effective in March. But remember, let's just say the rating decision was effective March of 2022, March the 7th. You're not going to get paid for the month of March because they don't pay partial months, and they're going to subtract what you've already been paid. So you got to start with the following month, and the month that you're in. So let's say you got the decision in December the 7th. Your back pay is not going to include the month of December because it's paid in arrears. You're going to get that month in January 1st. So depending on how you calculate it, you could easily overshoot. Okay, and I've seen a lot of people do that. So start if that were the situation, 7 March effective date. on a December 7th rating decision, let's put it that way, you're going to start April 1st is for payment purposes, and you're not going to include December. So your back pay should be everything in between there from April through November, and subtract the 100% rate from the 60% rate, and that's kind of how you calculate it. And I remember they do, if they input this stuff correctly, they're using a calculator. Okay, and so it's not somebody sitting there adding this up. So generally, they're correct, but that does not mean they don't make mistakes. We've seen them make several, but it's out of the norm. So just keep that in mind. So make sure you're calculating it correctly before you try telling VA that they haven't paid you correctly.
Hello, I was deemed 100% permanent and total. What can I do to help mitigate the chance of me losing that over time? Um, well, I would say the first thing would be to limit, if not um, n- completely just not file new claims unless it's something that you really need to file. If you're already 100% permanent and total, and you really don't have any reason to file additional claims, then you're going to prevent CMP exams, or you're going to prevent certain things that may trigger some type of evaluation that may trigger a reduction in one of the conditions. Um, I think that that's probably the best way. I think there are certain, Carrie, you can correct me if I'm wrong. If you're filing for an additional benefit on top of the 100% permanent and total, I believe that that's different, like SMC or something like that. But to go in and file a new claim, say for an issue that you're not currently service connected for, could put you in a position that could risk the permanent and total.
Yeah, no, that's my advice too. Don't. The short answer to that is don't file any more claims. Period. I know some people don't like to hear that, but if you're 100% permanent total, uh, most of the time the answer is don't file a claim. Now, let's say you're a Vietnam vet and you're 100% for mental health condition, and you get Parkinson's and now you're in a wheelchair. Uh, yeah, there's times when you're going to want to file a claim because there's going to be additional benefits. And those are rare circumstances, and you should probably seek advice before you do it. Because you've been in that wheelchair from Parkinson's, it's a presumptive disease for herbicides. Yeah, you could get additional benefits there. But if you're service connected for, say, a variety of things and you just happen to be 100% permanent total, or you're on TDIU, which is usually considered permanent total as well, and you have a bad knee that you think you want to file for, don't. It's not going to help you in 99% of the cases. Okay. And so take care of yourself, live your life, get all the health care you can, just don't file a claim. And that doesn't mean you can't use the ancillary benefits of being 100% permanent total. Chapter 35, dependents educational assistance, that's not the same. Just don't file a claim for additional compensation.
Can anything be done to expedite the C-file request? I requested mine in October and it's been marked received. I have my regular records, but mental health isn't included in the primary records file. Marked received. Um,
I would say, yeah, that's a. Here's the thing: the way the question, mental health isn't included in the primary records file. Does that mean you're talking about your mental health treatment records from VHA? Because remember, you have a claims file if you have claims or getting compensation. You have a healthcare record. Those aren't necessarily the same thing, so don't always think about them as the same thing. Uh, and so, if you want a copy of your health records from your treatment through VHA, then you should do that through the medical center. It usually doesn't. They can sometimes give them to you right then and there. If you want a copy of your claims file, which is usually done on their privacy request, uh, Give you a little story. The other day, literally the other day, like 2 weeks ago, I got a disc from VA. Now, I don't request records anymore, usually through the normal records request because we get electronic access to all that stuff. But I got a disc, and it was on a client that I had not made a C-file request for. Then it dawned on me, wait, I did. Before I actually had access, I did initially make a request. That request was over 3 years ago, and
Wow.
I got that disc a couple of weeks ago. Yeah, the long version of getting a C file from VA, it takes, and I don't know why they do that, why they take so long. Now it shouldn't, most of them don't take 3 years. I don't know, maybe that was an outlier. Usually it's like 6 months or a year, but yeah, I wish I could tell you a better way to get them faster.
Yeah.
Everyone has that problem when they're trying to do that.
Just really quickly, on that one, Riley did put a comment in over here that said he was referring to his mental health records when he was active. So he's waiting for the C file to get those service treatment records.
Okay.
Do you think that claims that were submitted before the Pact Act that have disabilities affected by the presumption changes will have their effective date set by the Pact Act? This is a question that we've talked about a lot at our firm. Kerry, I'm going to let you answer it since you have been the one that's really gone through all of this and explained the effective dates to us. So I'll turn it over to you.
Um, well, I mean, the meat and potatoes of it is we don't know yet because we haven't gotten any decisions from the Pact Act. So we can only answer that in accordance with the way the law is supposed to work. It doesn't always work the way it's supposed to. If you had a claim pending that's affected by the Pact Act, all right, that's definitely a presumptive now because of the Pact Act, then you really have two different claims. So, I mean, you have one claim, but that's affected by two different rules, the rules prior to the Pact Act and the rules after the Pact Act. Okay. Now, I fully anticipate VA giving you the effective date of the Pact Act in August of 2022. Okay. Whether you had that claim pending 6 months prior or 6 years prior, I fully anticipate that's the effective date you're going to get. I hope I'm wrong on that. But here's the thing, if they grant it in accordance with the Pact Act and grant it as a presumptive condition, then they can only grant it from August of 2022 as a presumptive condition. Prior to that point, the claim was a direct service connection claim, not a presumptive service connection claim. A direct service connection claim, you need the incident and service, the diagnosis, and the medical nexus. With the presumptive claim, you don't need the medical nexus. It's presumed. It's presumed that it's as likely as not that the exposure caused the disease. So that doesn't mean you can't get an effective date prior to the Pact Act. Obviously, first, you had to have had a claim pending prior to the Pact Act. There are going to be cases where we can't get an earlier effective date because we can't establish a link between the condition and the exposure through a medical nexus. And in those cases, they may be limited just to the August 2022 effective date of the Pact Act. But if your claim was pending a month or two prior to then you're going to have to make a call. Is it worth you trying to appeal that for the extra couple of months? All right. Let's just say you've got a claim pending for 6 years prior to the Pact Act. All right. You've got a lot riding on that. But prior to the Pact Act, it's a direct service connection claim. So if they grant you benefits effective the day of the Pact Act, what you're going to have to do is come in and appeal for an earlier effective date. Don't file a new claim. Keep it on appeal. your issue becomes the effective date, and you're still going to need a nexus to get that element of the claim, which is entirely possible for the majority of these conditions that are presumptive, because they made them presumptive for a reason. Because we have science that shows they're related to these exposures. It's just a matter of being able to get a nexus. You might be able to get that through VA in some circumstances. Don't rest on that. But usually you're probably going to have to get your own opinion one way or the other. And so that's how I anticipate it working. We will see. At the same time, we've seen the board in a couple of cases grant, and they gave the original effective date prior to the Pact Act, even though they're not doing Pact Act claims per se. These were claims that would have otherwise been affected by the Pact Act. So if you've got an appeal pending and it's been pending for a while, I would make sure you keep that thing pending. I would not withdraw it and file a new claim under the Pact Act. You can always add to that with a letter or something, but we are now in 2023. We should be getting decisions under the Pact Act. We don't know when that's going to happen, other than they are supposed to be making decisions now under the Pact Act as of this year. I haven't seen any. Shelly, have you seen any come across?
Not from the regional office. I have not. I have. We've had a couple carried decisions from the board that approved claims that would have been affected by the Pact Act and awarded them with the original effective date as direct service connected claims. Could have been influenced by that, but we wouldn't know that based on the decision. But I have not seen any initial claims or claims from the RO. If a veteran is at 100%, oh, sorry.
No, I was just going to say there's a lot of questions coming in, and we're not going to get to them all. We'll try, but they're coming in fast. So, no, go ahead, Shelly. I'm sorry.
That's all right. If a veteran is at 100% permanent total but have other claim pending as tinnitus, can it be closed? I would say yes. If this is the issue like we were talking about earlier, where you're 100% permanent in total and you're happy with your rating and you really don't want to push the boundaries anymore, I think you can submit a letter or a statement to the VA letting them know that you would like to withdraw that service connection claim, and that you don't wish to pursue it anymore. I think you should probably definitely do it in writing, but I don't see that that would be an issue.
No, that's not an issue at all. And I would say that your 100% permanent total satisfies all issues pending on appeal or otherwise. If you want to do something like that, just to make sure there's no, sometimes appeals, there's one straggling issue that stays on appeal that you might not be aware of. But yeah, you can absolutely withdraw those, and you should. If tinnitus is not going to get you more than 100%. So.
How long do you have to file for back pay after a decision? I heard it was 90 days. I'm not sure. Exactly sure about this question. Um,
I think they're talking
After
about.
a rating decision, you have a year to file an appeal for an earlier effective date. Not sure if that's what this is referring to.
That's how I take it, Shelly. Uh, if the question is premised on that you're just filing for back pay, um, there is there's no standing claim of earlier effective date. Okay, so in other words, you can't just come in out of the blue and say I'm filing for an earlier effective date. They're going to say based on what? Are you appealing a decision we just issued and disagreeing with the effective date? Because that's how you should do it. Are you saying there's a clear and unmistakable error in a previous decision that should warrant you an earlier effective date? Got to be clear there. Are you saying there's an unadjudicated claim or an appeal that VA never processed? Again, got to be clear there. But just to go in and say, all right, you got a rating decision 3 months ago, and you're happy with the rating, and now you come in and say, I want an earlier effective date, they're usually going to, well, one, it has to be on a form. Uh, Prior to the forms, they're usually going to take that as an appeal for an effective date uh, of the recent decision. But, you have 1 year, not 90 days, and it has to be phrased as an appeal of that decision. There's no standing claim for an earlier effective date. Keep that in mind. I hope does that make sense, Shelly, to you think to everybody?
Yeah, it does. What is the best source that has a list of heart conditions are eligible? What conditions are heart conditions secondary to? Where do I find that info? Um, so I'm not sure. Again, I'm not exactly clear on the question here. If you're talking about heart conditions that are presumptive to certain exposure, or if just in general it's a cardiac condition that you're trying to get service connected for that you were treated for in service. Um, I mean, any of those could be proper claims. You could have been treated for a cardiac condition in service and filing a service connection claim now. Could be a presumptive condition based on exposure. Um, I, Kerry. Can you clarify? Do you have
I
any
well,
on that?
I interpret that question to mean what's a list of presumptive heart conditions for like herbicide exposure. Um, if that's what you're asking, then there's one heart condition because hypertension is now presumptive, but that's technically a disease of the veins and arteries. Uh, Ischemic heart disease is the only presumptive heart disease for herbicide exposure. Now, there are various things that count as ischemic heart disease, and you would find that at in VA's rating schedule. If you want to look up the regulation, it's 38 CFR 3.309E. That has all of the herbicide regulations listed there. It will tell you one of them is ischemic heart disease, and it will tell you beneath that, what that includes, and that includes arterial sclerotic heart disease, coronary artery disease, myocardial infarction, angina, some weird angina that I can't pronounce. Um, you know, it, and that's most of the time you're talking a heart attack, coronary artery disease, which is the same as ischemic heart, which is the same as arteriosclerotic heart disease. If you're getting into atrial fibrillation and some of those things like that, those sometimes are not ischemic, so they're not going to count. But really, I think that's what the question is. Go look at 38 CFR 3.309E. That will answer your question in accordance with the actual law. And then hypertension is a new one. Now, hypertension could turn into a heart condition if you've hypertension, you've got long-standing hypertension, and now you've got an enlarged heart because of the hypertension, and maybe you've got hypertensive heart disease. But that's a little nuance there that's not expressly listed in the regulations. So uh, if you mean something else, then I'm not sure. Now let me go a little further. You might mean what if you got something within a year of service? Well, if you're going to look at those things, and I don't think that's what you're talking about, but just on the slight chance that it is, then you would look at 38 CFR 3.309A. 3.309A has your list of conditions that, if diagnosed within a year of service, are presumptive. Subsection E, has the list for herbicide exposure. And that will include all the new places under the Pact Act, like Thailand, Johnston Island, all that stuff. That's where you're going to go to find those presumptive conditions. So hopefully that helps.
Hello, I recently convinced my uncle to pursue compensation. He's a Vietnam Purple Heart veteran. Where should I start? Um, Well, I would definitely start by looking at the presumptive conditions and seeing if your uncle has any of those conditions, and filing for those. I think that's probably a good start. And then if there was anything else that he was treated for um, in service as well, Kerry.
Yeah, I would say start with if he's never filed a claim for, as far as the steps go, uh, start with a VA form 21-526. And I mean, that's the first step per se in filing a claim. If you never filed a claim before or never filed a claim for a specific disability, VA requires that form, that claim to be on a 526. That 526 allows you to list multiple conditions, like we said earlier. It's going to ask you your name and address and social security number and all that kind of stuff about when you served and all that. Um, and like Shelly said, if you know, obviously you want to know what you're filing for. So what is, maybe it's the injury that he received a Purple Heart for. Um, if that's it, again, you start with a 526 and you list the injury, whatever that may be, gunshot wound to the leg, as an example. You know, and it's going to ask you on there where what's the source of the disability. You would probably put like combat Vietnam, something like that. And that's going to start the claim. They're going to send you some letters and asking what kind of evidence you have. Best thing to do is give them all the medical records that you have. Uh, if you get treated at the VA and always have, then just let them know on that form, the spot for it, that you get all your treatment at the VA Medical Center. They can download those directly into your claims file. Uh, so that's where I would start. It's not as complicated as a lot of people make it out to be. Uh, and VA is, if you've never done it before, first thing VA is going to do is go get your service records, all right, your service medical records, put them in the claims file, take anything that you've given them to support the claim, put them in the claims file. They'll probably set you up with some examinations. You're going to get notified. All those go in the claims file, and then your claims file is built from that point forward. Everything you give them is going in there. Everything they send you is going in there. So that's basically it.
Good afternoon. Thanks for all you do. Thank you. I recently had surgery on my neck. I have filed as a secondary condition to my service connected shoulder and recently filed for convalescence. What can I expect?
Uh,
Um,
well,
Go ahead.
I so surgery was on the neck, but your shoulder is service connected. Uh,
Yeah.
and I hate to say this, but I'm just being kind of blunt and honest. I would expect a denial of the convalescence claim, because if the convalescence is not for a service connected condition, they're not going to grant convalescence. Has to be now. If your shoulder service connected and you had surgery on the shoulder, that's a different story. So you're going to have to get the neck service connected secondary to the shoulder. It looks like you're going down that path. Um, if they grant that, and they might, I don't know the facts of the case, then they should also grant the convalescence along with it. Okay, but if you just filed for convalescence because you had surgery and you didn't file a service connection claim for the neck secondary to the shoulder, uh, it says I have filed as a secondary condition to my shoulder. Recently filed a convalescence. So it sounds like you had filed two claims there. Um,
Yeah.
if they don't grant the service connection secondary to the shoulder, they're not going to grant the convalescence. And so that's what you should expect is uh, do what you can to get the neck service connected. And then the convalescence should follow in a natural course at that point. So hopefully that makes sense.
Yeah, that makes sense. In September, I was given the diagnosis from a psychologist PhD for PTSD due to a documented training accident. I have met with the social worker 9 times since then. I have an appointment with the psychologist tomorrow. Do I wait to see if treatment I'm going to assume that says works or cuts off after the
Yeah. Nate, is there a different
maybe.
part to that question?
I'll read the end of it for you.
Okay, thank you.
Do I wait to see if treatment works, or should I file a claim for PTSD now?
File the claim.
I would file a claim. Yeah, definitely.
Yeah. I mean, look
Yeah.
at this way. Let's say treatment worked. All right. And it brings the PTSD under control. All right, with no problem. Does that mean you don't have the PTSD any longer, or is it just not very disabling any longer? All right, and so I would, and odds are, once somebody gets PTSD, it's not something that technically just goes away, even though it might not be very severe and it might not affect you at all. You don't have to file a claim for it, but I mean, if that's where you're going with it, I would. And you've got the documented training accident, well, then I'll file a claim for it.
Yeah, I agree, Kerry. And if anything is, once you're service connected for it, anything happens in the future and your symptoms do worsen, then you can file for an increased rating and you don't have the hurdle of establishing the service connection.
Right.
Are VA caregiver benefits available for mental health care? The
Well,
answer to that should be yes. As long as all of the other eligibility requirements for the VA caregiver program are met, it being that the condition is mental health should not make a difference.
right. Yeah, but now it is going to have to be severe, like Shelly said. It's going to have to support the caregiver benefit.
Yeah.
That you're going to have to look at what's required for that. And just because, let's say we had a case the other day where that was 70% for mental health and receiving unemployability benefits, and it was accurate. It was the 70% was an accurate rating, but the TDIU, the 100% grant for unemployability, was also accurate. He filed for caregiver benefits. Not going to get it. I'm sorry. I mean, in my opinion, I obviously I can't adjudicate the case. I don't think he's going to get it. You're not going to get caregiver benefits just because you're getting 100% for something. All right. The caregiver benefits means somebody has to basically be there with you all the time due to a service connected condition and keeping you away from harm and all that stuff. With a mental health condition, that's what it's going to hinge on. Are you a harm to yourself? Because you're going to want to try to establish entitlement to aid and attendance. It's hard to do that with a mental health condition. If it's not rated at 100%, it's probably impossible to do that, at least in most circumstances. So you're looking at something that's going to require 100% rating for mental health and something severe enough to require you to need assistance because you are a danger to yourself if left alone. So those are high hurdles. Keep that in mind. That's all I'm saying. It just, hopefully that makes sense. But yeah, you can get those for mental health. We've seen it plenty of times.
Yeah. Is hypothyroidism now considered a presumptive condition to burn pits under the Pact Act?
I don't think so.
Okay. I don't believe so either. It
Yeah. Not for burn pits. I mean,
right.
and we don't have it in front of. We don't have the act in front of us.
Uh,
But in my recollection, and I've looked at it several times, the burn pit presumptions are mostly cancers. Now there are some respiratory things in there, Uh, but I don't think hypothyroidism was in there. Now, it is for
I,
herbicide exposure. Go ahead. I'm sorry. Go ahead, Shelly.
no, I agree with you. I think that might be the confusion there is that it is for herbicide exposure, but to best of my knowledge, it is not for burn pits.
Yeah.
I don't think so.
Yeah, and because some people may get that mixed up because you've got herbicide issues and burn pit issues all within the Pact Act. Um, so it's very easy to get that confused. But
Mhm.
because for herbicide exposure, it added a bunch of locations and added hypertension, and hypothyroidism was there already, but it's very easy to think that, oh, well, the Pact Act added hypothyroidism or added burn pits, and it's easy to get all that stuff mixed up. But I don't think burn pits. Now, having said that, let me preface this too with it. That doesn't mean you can't get service connection, okay, for hypothyroidism secondary to burn pit exposure. There are plenty of things, in my opinion, that those burn pits could potentially cause that are not on the list of presumptive conditions. Okay, and that's how we fought these claims for the past 10, almost 15 years, was direct service connection um, without a presumption in place, and we prevailed in a lot of those claims. But just we had to do it the hard way, getting an opinion and linking it directly to the exposures. Um, you can do that, in my opinion, with most. Let's look at your herbicide presumptives. I don't think there's really a herbicide presumptive that you couldn't get service connected one way or the other. It might be a struggle in some of them related to the burn pits. Why? Well, one is because the burn pits put out the same dioxin as the herbicides. And as all you know, that's just one of the many toxins that was produced by the burn pits. Uh, so there's some overlap there. Parkinson's disease is not on the list for burn pits. I think it should be. Uh, and I would not turn away a claim of service connection for Parkinson's if somebody needed help with that, secondary to burn pits, just because it's not on the presumptive. And because it is on the presumptive for herbicides, um, Parkinson's is pretty bad to have. And there's lots of things we know now, lots of toxins that cause it. To include lots of other stuff that's not on that list. So don't let it keep you from filing claims for it. The Pact Act was the start of burn pits. It does not mean it's the end. So just keep that in mind.
Yeah. Okay, guys. Thank you so much for watching today. Unfortunately, that's all the time that we have. We will see you guys again soon, and take care.